morning is the case entitled Richard Welch Jr. versus Nicholas Deml, case number 25 AP 121. Appellant Richard Welch Jr. is self-represented and is appearing by phone. Representing the appellee Nicholas Deml is Brendan Sage.
All right, thank you very much. Mr. Welch, before you begin with your argument, you have filed a document with the court indicating that you wanted to not have your hearing be public. You've asked to keep the oral argument private. These are public hearings, sir. Do you understand that?
Yes, I just didn't know if you were going to send Brendan Sage my oral argument. I didn't know that's what I was talking about. Sorry.
Oh, okay. All right. Very good. Well, I'm sure that you should have sent him what you filed, and if you haven't, you should do that.
Okay.
You now may proceed with your argument. You have 5 minutes, sir. Go ahead.
Okay. Allegations of verbal commitments. Verbal assault, DOC engaged in hostile, threatening, and degrading verbal conduct towards me, violating standards of professional conduct and detainee rights. Mental health access denied. I was refused access to requested mental health service despite verbal assurance and such care would be provided as stated in DOC policy. Grievance suppression, DOC staff tore up written grievances forms submitted by me despite verbal acknowledgement that grievances would be accepted and processed. Justified searches. I was subject to repetitive and unnecessary searches of my cell in person without proper cause of documentation, violating my assurance of procedural fairness. Emotional distress. The cumulative effect of these actions caused me significant emotional harm contrary to verbal commitments to upholding my well-being. Slander, detaining, defamation. DOC staff made false and damaging statements about me to other inmates and detainees along with staff despite verbal commitments to maintain confidentiality and respect. Innocent until proven guilty. My U.S. and state constitution allowed to be innocent until proven guilty by a court of law. DOC not only violated my constitutional right, but stole my personal property as clothing, etc. during a cell search, leaving me to have to purchase it all again. My belief and claim, I believe that if we don't have the DOC looked at and corrected for their actions through the Commissioner of Corrections, the problems that I have had will get worse. The DOC Commissioner is not above the law and needs to be held responsible for these actions like every inmate that is sentenced to do their time. I'm strongly incurring their responsibility for their actions. Thank you for your time. I'm done.
All right, thank you, Mr. Welch, and you may reserve the remainder of your time. Please, counsel for the appellee, please introduce yourself and your client, and you may proceed with your argument.
Thank you, Justices. Thank you, Justices, and may it please the court. My name is Brendan Sage. I'm an Assistant Attorney General in the Department of Corrections Litigation Unit, and I represent Nicholas Deml, the former Commissioner of the Department of Corrections. I'd emphasize that we rely on the arguments in our brief, and I'm happy to answer questions at any time. But just as laid out in our brief, the trial court was correct to dismiss plaintiff's amended complaint to the extent that plaintiff sought to sue defendant in his official capacity pursuant to 42 U.S.C. Section 1983. This court's decisions in Bach v. Gold and Murray v. Yee, cited in our brief, make clear that Section 1983 actions are not maintainable against state officials in their official capacity. To the extent that plaintiff sought to sue defendant in his individual capacity under Section 1983. The amended complaint failed to allege any personal involvement by defendant Deml. It's perhaps understandable why plaintiff named Mr. Deml as the only defendant, given that he was the commissioner of corrections. And the Thompson decision cited in our brief does lay out some circumstances when a higher level official can be considered sufficiently personally involved in unlawful conduct without directly participating in it, such as when the higher level official directs the conduct or becomes aware of it through something like a grievance or a letter, or creates a policy or custom under which the conduct is carried out. But here the amended complaint simply named defendant Deml in the caption and then made no allegations against him at all in the body of the complaint. And the Thompson decision makes clear that pure respondeat superior is not sufficient to hold a higher level official personally liable under Section 1983. And then just briefly, as noted in our brief, the trial court did not address any potential state law claims by plaintiff, but to the extent that he may have intended to raise any state law claims, defendant Deml was absolutely immune from those claims. The Lachey case cited in our brief makes clear that absolute immunity applies to the Commission of the Department of Corrections. And here, to the extent that there were any allegations against defendant, they were within the general authority of his office. And so for all those reasons, and reasons set forth in our brief, we would ask that this court affirm the trial court's grant of the motion to dismiss.
All right, thank you very much. Mr. Welch, does Mr. Welch have any time remaining, please?
Appellant has 2 minutes and 34 seconds remaining.
All right, Mr. Welch, you have some additional time if you'd like to respond to anything that the opposing counsel has stated, or you may choose not to do so. That's up to you, sir.
Okay, the only thing I have to say is that Nicholas Deml is the Commissioner of Corrections. Yes, he has immunity, but he's the only one that can make the changes to the policies, be that he is the Commissioner of Corrections. And the grievance process is unable to do so if people are going to be ripping up grievances. That's all I have to say on it.
All right, thank you very much. Bailiff, please call the conclusion of the case.